Supplementary cause list. Item number 1 for pronouncement of judgment.
I think I'll go with the consensus of all.
Well,
See, the advertisement itself is defective, not adhering to the relevant rules. Even if it survives, petitioner is not qualified, neither respondent name. So, in all fairness, I think we have to.
well,
So, I'll read out the operative portion. The advertisement dated 15/1/2015, published in newspaper on 6/1/2015, is hereby set aside and quashed. The whole selection process thereto is now brought to naught. Consequently, the recommendation and appointment of the respondent number 9 also stands quashed automatically. The interim order passed in this connection is hereby made absolute. The school authority managing committee is hereby directed to issue fresh advertisement for the post. However, in accordance with the prevailing rules and regulation as regard appointment of an assistant teacher in deficit higher secondary schools of the state. Petition disposed of, no cause.
that's right.
Thank you.
Hello. Your Lordship's indulgence to make a mention of item number 6, Willards.
Excuse me.
Plus, this matter has been heard by your Lordships is fixed for filing of written submissions by both the parties. Plus, I'm praying for a week's time in that matter.
I also pray for 1 week time to file it.
On prayer made by the parties seeking time to file the written argument, matters adjourned, listening after 1 week.
Right.
Item number 14, my lord.
Yes.
Praying for some time, around 2 weeks' time.
Any objection? On prayer made by the petitioner, list this matter up to 2 weeks.
But if it could just be the last adjournment because it keeps.
It will come in due course.
Receive some information about item number 7 and 9 you receive for the day.
Please, Your Lordship. For item number 7, Your Lordship, the last order speaks for itself, Your Lordship.
Some information for the day only you receive.
I have a strong objection, Your Lordship. It's 2017 matter.
No, the fact is, Mr. Devnath, you are not able to get those communication. Simple as that.
This too, you receive.
So, either what you can do is, you can bring some relevant authorities in that regard to say that
I was trying.
to say that those absence of those notification will have no bearing in the case of the petitioner. Otherwise,
This
maybe.
I was trying to have, but it's I didn't.
I don't think there's any
2 months,
authority.
Your Lordship. Time
No,
has
this
elapsed.
is some.
Have you also given any authority in that regard
We have supplied, Your Lordship.
with regard to that specific point?
Your Lordship, pertaining to the service of.
Yes.
Your Lordship, we have done our part.
What do you want now?
Some for two,
Sometime forward.
The judgment be rendered, Your Lordship. If they agree, then they can go for any appeal. Or
Have you filed your written argument?
I've given some synopsis, Your Lordship. Some authority just I was trying. Only some authority.
How long can we wait? Need to kalas udah mo. This made clear no further adjournment will be granted.
Your Lordship, possible, Your Lordship. I have some personal.
Enough
One
time
other
has
matter
been
is
given,
there.
Your
After this, I
Lordship.
have to go somewhere, Your Lordship. Another matter is there. I have to argue today.
Since 2 months, Your Lordship. Time has been given since 2 months. Enough time has been given, Your Lordship.
Mr. R. Demna, Leonard CJC, has again stood up seeking accommodation in this matter on the ground that certain relevant authorities are required to be produced by the respondent Union of India, for which the same could not be produced today. The petitioner has raised a strong objection to the prayer made on the ground that the previous order of this court would reflect that no further adjournment will be allowed in this matter. This court is constrained to comply with its own order. However, for ends of justice, the prayer of the Leonard CGC is allowed. It is made clear that this will be the last and final chance for the petitioner, for the respondent, to state his case. As such, matter is adjourned. Today is
28th.
this matter on 28. 28. No more chance.
Oblige, Your Lordship.
Your Lordship, item number 9.
Who's for
Item
the,
number 9.
We are for the petitioner, Your Honor.
that is who, that list you have not brought.
No, Your Lordship, in this matters, to have the instruction regarding this whether ban is withdrawn or not. So
The
not
ban only
any instruction is not in been received.
on premier by the Leonard CGC, not objected to by petitioner. List is met after 2 weeks.
Lordship, I beg to mention item 12. Lordship, I require some more time to prepare this matter.
On premier by the petitioner, list is met after 3 weeks.
Highly obliged.
May it please, Your Lordship, I beg to mention item number 10, Your Lordship. The matter may come up after 2 weeks, Your Lordship.
You are for?
Petitioner, Your Lordship.
On premier by the petitioner, list is met after 2 weeks.
Lordship, I'm appearing on behalf of respondent 5.
Highly obliged.
Lordship, I beg to mention hearing item number 8, Lordship. I pray for some more time. Number 8.
You have to file your
Written submission, Lordship.
written argument.
Yes, Lordship. Written argument.
Who's appearing by petitioner?
Mr. P.K. Bora.
You are here in this case. Have you filed your written argument?
Yes, Lordship. Yes,
No,
fine.
petitioner?
They have filed. They have filed.
On premier by the Leonard Additional Senior GA,
Lordship.
seeking time to file the written argument. Matter is adjourned. This is same after 2 weeks.
Obliged.
Your Lordship, for item number 13, I pray for some more time. 13.
30.
On premier by the petitioner, this is matter after 3 weeks.
Lordship, I would like to mention item number 11. Lordship, in the next 2 weeks' time, Lordship.
You are for?
Respondent, Ms. P. Bhattacharya.
Yes, who's
I'm for the petitioner. No objection, or she's on leave. So
She's on leave.
on premier by the respondent. on the ground that the conducting counsel is on leave, but is not, and the same not being objected to by the petitioner, but is adjourned. Please stay up to 2 weeks.
My Lord, I beg to mention item 4, my Lord. Item 4 of the hearing list, my Lord. The matter can come up next week. It's a very short matter. I just want to give the list of judgments.
My Lord, it can be a joint prayer. I have no objection because my colleague is also not available today.
On prayer made by the parties, list is matter to 1 week?
1 week.
1 week.
Please, Your Lordship, would like to make a joint request. Item number 3, Your Lordship.
Number?
Item number 3, Your Lordship.
3.
Yes, Your Lordship. It's a joint request, Your Lordship.
This matter has not been heard.
It has been heard once, and for some clarification, it was left. It's a POXO conviction, my lord. So we have to start from the beginning, my lord, since so much time has lapsed.
How many years of conviction?
7 years, Your Lordship.
And how many years is he in custody now?
Next year will be the last sentence, Your Lordship.
Next year will be 7.
Yes, sir. Lordship.
So we'll wait till next year.
Your Lordship. Well, just give us 1 week time, Your Lordship.
On prayer made by the petitioner, appellant, list is matter of 2 weeks.
Supplementary cost list, item number 2.
Excuse me.
My lord, before I begin, my lord, there is a small error in the cost title, my lord. Respondent number 2.
Yes.
In fact, the FIR is filed by my lord. If lords kindly comes to page 20, my lord. The FIR is filed by Ayush Dhanania, my lord. And by mistake, because these are two brothers, my lord, and the proceedings in Calcutta, my lord, both of them are accused there, where we filed a complaint, my lord. So, my lord, I may be permitted to correct this, my lord, by hand, my lord.
What is this? Okay, tell me what's the matter.
Well, here what happened, my lord? The petitioner company got a contract for supply of PHE pipes, my lord, under Jal Jeevan Mission, under PHE Department of Government of Meghalaya, my lord. The contract was about 135 crore rupees, my lord. And it involved about around 1,000 trucks of pipes, my lord, to be supplied to Meghalaya. So, being a manufacturer and a large scale operator, my lord, what we do is we engage logistics companies, my lord, for transporting to various destinations. So 3 companies were engaged by us for transporting the pipes, and we also engaged one commission agent, my lord. What he does, because for us it is not possible to liaison with the government of Meghalaya for payment and other things, my lord. So we appointed the respondent number 2 as a commission agent, my lord, and we dispatched all the pipes, my lord, as per the terms of contract to PHE Department of Meghalaya. When we did not receive full payment from PHE Department Meghalaya, my lord, we inquired why payment are still outstanding. PHE Meghalaya informed us, my lord, that goods worth rupees 13.5 crore rupees were never received in the godown of PHE, my lord, in Meghalaya. Total contract was 135. Goods worth rupees about 16 crore rupees were never delivered. In fact, what it appears, my lord, they instructed the truck drivers not to come to Meghalaya, but rather go to some other place, my lord, unloaded the pipes there, and they took the money payment from those parties, my lord. In fact, we never, so it's a clear case of breach of trust, my lord, because we handed over the pipes to the commission agent, to the transporters, and they, instead of delivering to the right destination, what they do is they divert it, sell it somewhere else in the market, my lord. So when this came to our notice, my lord, we filed an FIR in Calcutta, my lord. Lordship will see that FIR at page 22, my lord. But this is in fact is a 156(3) complaint before the magistrate to register an FIR, my lord. And pursuant to this, FIR has been registered. Now, your lordship will see here the parties at page 22, my lord.
Yes.
Number 1 is Raj Carrier Private Limited, is a transporter. Srinivas Roadways Private Limited, he is also a transporter. Manish, number 3 is Road Transhippers of India, that is also transporters. And 4, 5, 6 are the directors of these transport companies, my lord. Here we are concerned with number 7, my lord, Ayush Dhanania. He was the commission agent. And Umang Dhanyania, they are the two brothers, my lord. It was number 8 in this case, before Calcutta, my lord. So, my lord, pursuant to the direction of CGM Calcutta, my lord, the police registered the case, and that has been registered in a police station called Sankrail, my lord. That your lordship will find at page 21, my lord. Sankrail, serial number 3, police case. Sankrail is a police station, my lord, somewhere near in Howrah district of West Bengal, my lord. Now, my lord, when this FIR was registered by police, my lord, they moved a 482 petition before the Calcutta High Court, my lord. Somehow, my lord, the Calcutta High Court, by order dated 12/4/23, my lord. The date is of some relevance here, my lord. Page 100 is the order passed by the Calcutta High Court, my lord.
Yes.
My lord, this is the registered as CRR number, criminal revision, I think. And ultimately, the Honorable Calcutta High Court quashed the FIR, my lord, on the ground that the matter involves civil dispute and there are no ingredients of any criminal offence. Now, my lord, against this order, we went to Supreme Court, my lord. My lord, you will kindly notice one important thing here, my lord. The Calcutta High Court quashed the Calcutta FIR on 12/4/23, 12th of April, my lord. And what the respondent number 2 does, my lord, at page 18, just after 2 days, taking advantage of that, my lord, on 14th April, he files an FIR in Joy Police Station, my lord. Then what happened, my lord? We went to Supreme Court against the order of the Calcutta High Court. Page 114 is the Supreme Court's order. An operative party, lordship will see page 116, my lord. I may just read 1 or 2 paragraphs. Mr. Siddharth Lutla, learned senior counsel, submits that the goods had been delivered, but this is disputed by Mr. Mukul Rohadgi and Mr. Ranjit Kumar, learned senior counsels appearing for the appellant. This being the position, we set aside the impugn order, but at the same time, direct that the respondents ought not to be arrested till the stage of taking of cognizance. We are passing this protective order, having considered state submission that the said 2 respondents are cooperating with the investigation. Mr. Luthra, learned senior counsel, assures us that his clients will cooperate with the investigation. Whatever the observation we have made in this order, the same are based on the stage at which the quashing orders were passed, and we are not foreclosing the options of the respondents to approach the appropriate forum and a subsequent stage for seeking relief, if any. My lord, the operative part is in the previous para, my lord. On going through the materials disclosed. On going through the materials disclosed, we do not think that at this stage of investigation itself, the High Court could have come to a definitive conclusion that the dispute between the parties was essentially civil in nature. At least the nature of the complaint reveals certain ingredients of criminality which are required to be tested in course of the procedure stipulated in the court itself. The law enforcement agency, on conclusion of the investigation, chose to submit charge sheet containing certain questions that ought to have been examined at the stage of framing of charge. So, my lord, the Honorable Supreme Court set aside Calcutta High Court's order, and the investigation has been restored before the Sankrail police station. The investigation is going on, my lord. My lord, lordship will see this FIR at Joy police station was filed at the time when the investigation on our complaint was set at naught by the Calcutta High Court, my lord. So maybe at that point of time, a counter FIR may have been possible, my lord. But after the said investigation has been restored by the Honorable Supreme Court, my lord, on the same facts and circumstances of the case, the question is whether the Joy police station can continue with the matter, my lord. And my lord, moreover, my lord, lordship will see the sections. The sections in the Joy police station case are, my lord, lordship at page 20 will see.
Yes.
Section 120B, section 469 and 34 IPC, my lord. Now 469, lordship will see the maximum punishment is 3 years, my lord. 3 years only. My lord, and moreover the contents of the FIR, my lord, if I may just take your lordship through the contents of the FIR. Whether any criminal offence is made out in the FIR on the face of FIR, number one, and number two, Joy police can investigate these issues, my lord. Because everything, even in the FIR, everything arises in Kolkata, my lord. Where lordship will see the petitioner company Jindal is based in Calcutta, the 3 transporters are based in Calcutta, and the accused persons are based in Calcutta, my lord. Now, I may just take your lordship to few paragraphs of the FIR, my lord. FIR starts at page 18.
Yes.
Now, may I read the entire FIR, my lord? It's 2 pages. I was appointed as authorized commission agent by Jindal India Limited to represent them in PHE Meghalaya for getting the materials cleared at consignee end to get the payment released to Jindal India Limited bank account from PHE at an early date. Our authorization certificate was signed and executed by employee of Jindal India Limited, Sri Ravi Shugla, in the month of March 2021, attached Annexure A. I was also trading in pipes and seats manufactured by Jindal on regular basis up to 2021. In 2021, I have paid Jindal India Limited an amount of rupees 1 crore 12 lakh so and so for purchase of materials, after which they denied to give the material and also denied to refund the money, following which I raised my matter with them in NCLT in 17 September 22, along with an interest amount of rupees 18 lakh so and so, totaling to rupees 1 crore 31 lakh rupees. Now this happens in Calcutta, my lord. Following which Jindal India Limited has filed a FIR in Howrah, West Bengal, by FIR number 1144 of 22, alleging that a few consignment of GI pipes sent to PHE Joy Division mainly has been diverted on instruction of myself and my brother, Mr. Umang Dhanania, to other places by the transporters of Jindal, and company has incurred a financial loss of rupees 16 crore approximately. Annexure of the said missing transporter LR, lorry receipt LR, along with corresponding truck number is attached as Annexure D for ease in tracking of the trucks in PHE records. Period mentioned by the Jindal for missing trucks is from March 21 till May 22. Jindal took a shield of this FIR in NCLT case to deny money to me. A copy of their NCLT reply affidavit is attached herewith. Jindal has sent me a copy of the FIR filed along with various supporting documents by email on 15/2/23 through its advocate on record Sri so-and-so for above stated NCLT case filed by me, Ayush Dhanani, on Jindal for recovery of rupees 1 crore 31 lakh so-and-so. I was shocked to see the supporting documents given by Jindal along with FIR, as many documents were prima facie contradictory in nature and posed by the Jindal for the benefit of its case 1144 so-and-so only. Jindal has annexed a document signed by Mr. Ramesh Bansal as director on a letter dated 25/21 to Chief Engineer Meghalaya, which is a forged document, as Sri Ramesh Bansal has commenced as director from 27/8/21. A copy of so-and-so. This letter is further countersigned and verified as true copy by Director Mr. Sudipta Bhawal on behalf of Jindal India Limited. Both Ramesh Bansal and Sudipta Bhawal are aware of the untrue act and has knowingly forged a document and submitted the same to police and Honorable Court in West Bengal. Our lawyer made a RTI to PHE for confirming the receipt of the letter by them, and they clearly denied ever receiving such a letter. Mr. Biplav Sen Gupta, employee of Jindal India Limited, was responsible in 2021 for third-party inspection before the dispatch of material from factory of Jindal in West Bengal, and presently representing in PHE Meghalaya, is hiding the fact that rupees 16.79 crore pre-inspected material has already been delivered to PHE from the said materials, and payment has also been received by Jindal in its official bank account for many of the alleged missing consignments. Despite receiving payment from PHE, they have made a criminal conspiracy against me for falsely accusing me of the alleged theft of rupees 16.79 crore rupees approximately. Since Jindal was aware of the actual delivery location of the said missing trucks, they have paid many freight bills of the alleged missing trucks to the said transporters even up to 2022, but despite making freight payments to transporters, they chose to file this misleading FIR. It further comes I further came across 3 different emails issued by Jindal by its transporters, namely Raj Carrier Private Limited, Srinivasa Roadways Private Limited, and Road Transport Shippers of India, which are highly contradictory in nature. The emails state that Mr. Ayush Jatia was director, whereas Mr. Ayush Jatia has ceased to be director of Jindal India Limited since 1/8/18. A copy of so and so. The email of Srinivasa Roadways clearly states that the materials have been directly uploaded by the truck driver at different PH depots, and most of the time received signed challan was directly signed and stamped by PHE officers, while delivery, and only in few cases Ayush Dhanani has signed the LR himself. Whereas the email of Raj Carrier contradicts the email of Srinivasa Roadways and states that Ayush Dhanani used to instruct for the delivery of materials at different depots, and Ayush Dhanani used to take the invoice at the time of vehicle reaching the unloading point and take responsibility of unloading. Email of Road Transshippers of India further contradicts the email of both Srinivasa Roadways and Raj Carriers Private Limited and states that Ayush Dhanania and Umang Dhanania used to instruct for the delivery of materials, and receiving was also arranged given by them. Whereas the fact is that the materials was directly uploaded by the transporters of Jindal at PHE depot was instructed by Jindal in third-party inspection report of Mr. Amin, and most of the time receiving was given directly to truck drivers by PHE officers. A copy of PHE confirmation of the few alleged missing consignments is also attached herewith as a proof of delivery to various divisions of PHE. Jindal is trying to threaten us through their West Bengal FIR that if we don't take back our NCLT case against them, then they will get us falsely implicated in West Bengal FIR. They will also deny all the authorizations given to us and straight away deny all our doings in PHE Meghalaya and get us behind the bars. My marriage ceremony was scheduled to be on 1/2/23 in Kolkata, which got cancelled due to the filing of this untrue case by Jindal White so and so. I pray to Meghalaya Police to kindly register a FIR in the said matter as early as possible and begin investigation of the forged documents and misleading facts given by Jindal India Limited. I shall be thankful for the rest of my life to Meghalaya Police for investigating the same in Meghalaya, as the alleged place of occurrence is Joai, Meghalaya, and itself in the interest of case if the matter is investigated here in Meghalaya. Ayush Dhanania, so and so, my lord. So, my lord, two important aspects, my lord. This FIR is filed on 14th February after the Calcutta FIR was quashed. Subsequently, that has been revived. All what they are saying in this FIR, my lord, in my humble submission are his defenses, my lord. These defenses he has to disclose before the Calcutta police, my lord, who is investigating into the matter. But in my humble submission, this is a complete counterblast, my lord. Now, after filing of this FIR, my lord, one very interesting aspect. Lordship has seen the FIR is filed on 14th April 2023, my lord. We are now on about 20th of June. For 1 month after filing of FIR, there was no activity by the police, my lord. After it has been, Calcutta High Court's order has been set aside by Supreme Court, my lord. The respondent number 2, my information, is camping in Joai, my lord, and somehow instigating the police to take action. And because of that, my lord, Section 41A notices have been issued asking them to come and appear before the police from Calcutta, my lord. Your lordship, all are residents of Calcutta. Section 91 notices have been issued to produce the document. In my humble submission, my lord, there are two parts of this FIR. One is purely defense, which the complainant herein should disclose before he should participate in the investigation which is going on in Calcutta, my lord. And these are his defenses, my lord. Now, our defenses cannot be a counter FIR, my lord. That was my first submission. Second submission, my lord, is saying that one letter was signed by some Mr. Ramesh Bansal, who was not a director of the company at that point of time. Number one, he is not agreed with that, my lord. If somebody is signing a letter on behalf of my company, our company, my lord, we should be agreed with that. And moreover, that letter has also been issued from Calcutta. So, my lord, even territorial jurisdiction of Meghalaya Police, my lord, is questionable, my lord, in this matter. Lordship will see this is purely a counterblast, my lord. Now, he has stolen about 16.79 crore rupees from the petitioner company. So, my lord, since Section 41A notices are being issued and 91 notices are being issued, and in fact, just last night they received 3 more 41A notices, my lord. So, my lord, in my humble submission at this stage, some protection is given to us, my lord. In the meantime, notice can be issued to respondent number 2. The matter can be finally heard. But at least no coercive action should be taken to arrest or anything, my lord, at this stage.
41 is not, it is not a warrant to arrest.
It is not a warrant, my lord, but they apprehend, my lord, if they come and appear, because the respondent number 2 it appears is quite influential, my lord. And that is why he has come all the way from Calcutta to file FIR in Joy, my lord. Otherwise, Joy has nothing to do with the present dispute, my lord.
Yes.
May it please your lordship. Lordship, so far the contention of my friend that Joy Police has no jurisdiction or territorial jurisdiction, in my humble and respectful submission, your lordship, going by the content in the FIR, your lordship, it appears, your lordship, that some transaction has taken place in the state of Meghalaya, your lordship. Lordship, kindly have a relook at page 18 of the FIR, paragraph 1, your lordship. Paragraph 1, your lordship, then page Meghalaya. So then, lordship, kindly come to page 19 in the bottom, your lordship. Whereas the fact is that the material was directly unloaded by the transporter of Jindal at PHE depot. So PHE depot, your lordship, this is in the state of Meghalaya, your lordship. So, yes, in my humble respectful,
this will not give a cause of action. This matter is being investigated by Calcutta Police.
This concern the PHE pipes.
Lordship, yes. Then,
my lord, the dispute is not with PHE.
Yes, yes.
Dispute is between us and our agent,
it's
my
true,
lord. What agent has done, he has gone and sold the pipe somewhere else, my lord. We have no elevation against PHE, my lord.
What I am submitting, your lordship, so far the territorial jurisdiction of the Meghalaya Police, your lordship. Just to canvass that, your lordship, before your lordship,
yes,
that the transaction, it appears, your lordship, from the FIR, it took place in the state of Meghalaya, your lordship. So in that view of the matter, your lordship, in my humble and respectful submission, certainly the Meghalaya Police will have the jurisdiction. Then another aspect of the matter, your lordship, whether those documents are forged or not, your lordship, that is a matter to be investigated by the police, your lordship, by the police. So my humble and respectful submission, your lordship, in this case, your lordship, it's not there is a prayer for interim relief, your lordship. It's not a fit case, lordship, because the fact remains that 469, your lordship, this is it's only the punishment is less than 3 years, your lordship.
Is it billable?
It might be billable.
It should be billable.
Lordship, I have to see. Let's see. Lordship, because that the notice 41A notice, your lordship, that is in compliance with the Honorable Supreme Court judgment in Anish Kumar case, your lordship.
That is for offences below 7 years.
Yes, your lordship. That is a lordship.
Well, there is no harm in giving that much, no coercive action shall be taken. We will cooperate with the investigation, there is no problem. We will comply with 41A.
Lordship, let the investigation go on, your lordship. Then
the matter will be 469, isn't it?
469 is cognizable but bailable.
Yeah, it's bailable.
My lord,
you can always apply for bail.
To subject them to bail, my lord, arrest and bail, my lord. They are from outstation. We will cooperate with the investigation. There is no problem, my lord. Only to the extent that no coercive action should be taken against them.
Lordship, let the investigation continue, your lordship. Then
yes, the investigation will continue.
Yes. So far that whether lordship, I leave it to your lordship, because since it is it's less than 3 years punishment, your lordship.
Dr. N. Musica, learned senior counsel appearing for the petitioner. At the outset, the learned senior counsel has submitted that there has occurred an error in the cause title, inasmuch as the name of the second respondent
should be Ayush Dhanani
has been incorrectly recorded, inasmuch as instead of the name Umang Dhanania, it should have been
Ayush.
Ayush
20.
Ayush
Dhanania.
The learned senior counsel has submitted that at this stage the error may be allowed to be corrected by hand. The respondent number 1 in the meantime is duly represented by the learned AAG, Mr. Andy Chulai. On this initial prayer, the same is allowed. The petitioner is to correct the same in the records of this court, and a corrected version of the petition be supplied to the petitioner, to the respondent number 1. As prayed for, let notice be issued upon the respondent number 2, the same returnable within 2 weeks.
I have instructions to accept the notice on behalf of respondent number 2.
It's good.
On acceptance of notice,
But,
the petition can be.
Have you filed a power?
I will do that. Once the notice is issued, I will file my power. They can serve me a copy.
Respondent number 2, the Mr. Iliman Nongri, Learned Counsel, has submitted at the bar that he is instructed to accept notice on behalf of the respondent 2. Accordingly, petitioner has to supply a copy of the petition upon the said counsel, who in due course will file his power accordingly.
If the matter can come up on Friday, go through the petition and then make a submission.
Let's see. Let's see. Upon hearing the submission of the learned senior counsel for the petitioner, though this court will not go into the merits of the submission at this point of time, suffice it to say that on the assurance given by the petitioner that the petitioner is a company, petitioner company, that it will cooperate with the investigation.
Petitioner company, it's maybe some others, we don't know whom they'll issue notice, my lord. All of them, they'll cooperate with the investigation. And its directors and other officers.
The petitioner company, through its director or official, will go on to next. Will cooperate with the investigation. Therefore, until further orders, no coercive action be taken against them, against the said company.
Said company and its directors and officers also. Because company is an entity.
Company means inclusive.
Just to mention that the police will never know.
So, director,
or
officers, peon, driver,
employees.
Who else? Directors and officers, and officials of the said company. This is matter to 2 weeks.
Lordship will kindly clarify that police will continue with the investigation, Your Lordship.
That is always there. I will cooperate with the investigation, which will continue.
Lordship, highly oblige, Your Lordship.
Daily cost list, item number 1.
Report from the police.
What is this case about, Mr.?
Lord, this is that NDPS matter, my lord. So the petitioner has been arrested.
My lord, three persons were arrested.
He's one of the accused.
And I am one of the accused. 2 persons were arrested on 6/3/2023 at a place called Umkyang, which is 60 kilometers away from Cleryhat. Those 2 persons, it is alleged that contraband were recovered from those 2 persons, heroin of 75 grams. And it is alleged that they disclosed my name, that I am the one where I was arrested from Cleryhat, not on the spot. They have said that I am the main person, so Accordingly, the police has arrested me.
According to the co-accused.
Accused,
He is the main accused.
yes, they have said that as per my instruction they have done. But one of the accused person from whose vehicle, private vehicle, and from whose possession the contraband was recovered, he has already been enlarged on bail on 18/5/2023 on the ground that he has done for want of money. So I also applied.
NDPS matter parity.
Yes, Lordship. But this is the quantity is intermediate quantity. Charge sheet has been filed, and but charges had been filed without FSL.
You have been arrested.
Yes, Your Lordship.
You are under arrest now.
Yes, yes. I am 106 days. I am inside.
106.
Yes, and it is intermediate quantity.
Charge sheet filed.
Charge sheet filed. Charge sheet is filed, but it is not complete charge sheet. FSL is still awaited, and the allegation is that I contacted that report. Mobile phone has been seized, and that report is also awaited. That is also not there. So the entire allegation that I am involved, that is, there is no, as of now, charge sheet. There is nothing. That because my mobile phone has still report is still awaited.
That will only be clear, my lord, once the FSL is received.
So in this connection, Your Lordship,
That
I will
is
just
also stated in the report.
rely on this judgments passed by the Honorable Supreme Court order, and based on that order, Honorable different High Courts has given their verdicts. And this is intermediate quantity, Your Lordship. That is only 75 grams. And I will just place, Your Lordship, because
only 75 grams, Mr. Pandit. Yes. Even if you say 5 grams, that would have a very, very serious impact and wide ramification as far as addiction is concerned. You introduce 5 grams, let's say 5 grams, or even less than that to a child or anybody else, he would become an addict for life.
Yes, Your Lordship.
We are talking about quantities.
FSL is still awaited. And on this count, Your Lordship, the Honorable Supreme Court, the matter is pending before the Honorable Supreme Court, and I will just read, which is passed on 1/5/2023. Your Lordship, that is, I'll just read, Your Lordship. The primary question sought to be, second paragraph, to be urged in the instant petition is with regard to petitioner having acquired a right to seek for statutory bail since the charge sheet filed is without FSL report. Next, that aspect of the matter at this juncture need not be gone into since the said issue is pending consideration in a batch of petition which would take some time for hearing, and this petition also to be considered along with those petitions. For the present, we note that even in other pending cases before this court, in SLP such and such and other similar petitions without reference to the statutory bail, taking note that the petitioners have been in custody for some time and the trial would take some time to conclude, we had directed grant of bail to the petitioner. In that view, in the instant case also, we direct that the petitioner be released on bail subject to petitioner diligently participating in the trial. All connected contentions are however left open to be considered with regard to the issue relating to the default bail. Based on this judgment, Your Lordship, next, the Honorable Madhya Pradesh High Court on 11th May 2023, in paragraph, second page, last paragraph, Your Lordship, on due consideration of submission, perusal of the case diary as also the order passed by this court, as also the Supreme Court in case of Ambalal versus State of Madhya Pradesh passed in such and such, and the Supreme Court in special leave, just now I said order, special leave to appeal such and such in case of Dias Bhardeva versus Nargrik, wherein in the cases where the FSL report has not been filed along with the charge sheet, the accused persons have been granted bail. This court find it expedient to allow the present application. So, based on this recent judgment order passed by the Honorable Supreme Court, Madhya Pradesh court has also granted bail.
The Supreme Court has passed its order in a bail against in a bail connected with
that issue is pending, Your Lordship. That
what is
whether
what is the section? What is the the offence involved?
This is NDPS case. All are NDPS case where FSL is that is pending, that matter is pending because sometimes the police used to submit the charge sheet without FSL. So that matter is pending whether it will be construed complete charge sheet or whether it can be statutory bail can be granted because the charge sheet is not complete in view of the absence of the FSL. In my case, FSL is not there, plus that pertaining to seized mobile also there is no FSL as of now. And Your Lordship, the Delhi High Court in the next judgment I have placed, Your Lordship, same Similar contention, Delhi High Court, Your Lordship, in paragraph 6 and 7, next page. In the instant case, 6 and 7, Your Lordship, Delhi High Court.
Yes.
In the instant the investigation has been completed and the charge sheet has been filed, the present petitioner has been arrested only on the basis of disclosure statement of the co-accused person, same as my case, Momin Sheikh and Sunil, and the bail application of co-accused, namely Sunil, has already been allowed wide such and such by this court on the ground that there was recovery of intermediate quantity. The trial would take a long time to conclude, thus no fruitful purpose would be served by keeping him detained in prison. Therefore, in view of submission mentioned here in above, considering the period of incarceration and the fact that the recovery was of intermediate quantity, the petitioner is entitled to parity with co-accused. And similarly, Your Lordship, next judgment by Gujarat High Court.
But these are different high courts.
Yes, in this, because only I want to satisfy this honorable court that intermediate quantity rigor of 37 is not applied.
That of course.
Yes, and Lordship, the Gujarat High Court in page number 3, in between the paragraph, however, considering the paper of investigation, it reveals that the quantity, even if presumed to be part of the plant to be ganja, is less than commercial quantity and higher than the small quantity. Therefore, considering the provision of NDPS at rigors of section 37 would not be applicable in the present case. At the same time, as coming out from the record, the applicant is also not having any other criminal record apart from the antecedent of the very same nature. I deemed it fit to release the present application on bail. This person was having similar allegations also. And the last, the Honorable Jammu and Kashmir High Court, which I referred on the last occasion also, that intermediate quantity bail was granted, that no fruitful purpose would be served by keeping the accused in jail.
So all this would be based on the facts of the case.
Yes.
Each case will have its own facts.
I humbly submit that, Your Lordship, because keeping the accused in custody would not serve, moreover he is not well also.
The Delhi High Court case, same, similar facts and circumstances.
What is there?
Intermediate quantity, co-accused have been released.
Lord, but here, Lord, in these cases, whether the accused is one of the main accused, because here there is a clear allegation that the accused is the main person behind this whole incident is.
Main accused, Your Lordship, the person from whose it was recovered, they are just, it is allegation.
Lord,
At this stage,
why would, if he is not involved, my Lord, why would he be?
Presuming, Your Lordship, I am involved also, then also intermediate, at least based on the FSL is not there, not even copies has been supplied, even although the charge sheet has been filed, investigation, Your Lordship, the copies has not been supplied, charges has not been framed, it is at initial stage, it will take its own time. Punishment is, maximum punishment is 10 years. Considering the amount of this quantity of the, I will get hardly, Your Lordship, 3 years, 2 years, considering the quantity of the contraband involved. So keeping the accused person, Your Lordship, it is used, no fruitful purpose would be served, Your Lordship.
But who is the, my Lord, where is the transaction? Who was the part of the transaction? It was the petitioner here.
No, that is not, it is still awaited.
Petitioner's charge sheet is at page 3.
heard Mr. S. Pandit, learned counsel for the petitioner. Also heard Mr. K.P. Parshadi, learned G, appearing for the state respondent. The petitioner, the learned counsel for the petitioner submitted that an FIR was filed. FIR was registered. Who was filed the FIR?
The police.
Well, it was the information which
Police
was
only.
given by the informant to the police.
SI S. Buyam.
An company on who has submitted that on an information given by one SI S. Boam. An FIR was registered
On the
by
basis of
the.
the information received from the informant. Raju Dakar.
He is the one, isn't it? He has given the information. S. Boam.
Raju Dakar.
Oh no.
No. The initial Naka was
formed.
Naka was there. The
Based on
vehicle
source
was
information.
intercepted. Thereafter, FIR filed.
Yes, sir.
So, okay, let's put it this way then. We'll go by the charge sheet. What does it say? Yes, Boam is the one who has filed the FIR.
Yes, sir.
Yes. Bangun untuk is Boam of Umkiang, PPP, East Dainty Hills District. Indicating therein that on 6/3/2023 at around 11 a.m. on credible information being received that a drug peddler named Raju Dakar was proceeding from Kalyan, Kachar in Assam towards Umkiang village, Meghalaya, with his friend in a vehicle, being a Maruti car. The police had accordingly set up a checkpoint and has intercepted the said vehicle at Umkiang. On a search being conducted, the police had recovered a packet covered with black plastic polythene, in which was found 7 soap boxes containing orange color powder materials suspected to be a contraband or psychotropic substances, more particularly heroin, which after the preliminary test was found to be positive for heroin. Accordingly, the occupant of the said vehicle, Raju Dakhar, who else was arrested there? Two. And Lamprang.
Yes, Raju Dakhar and Lamprang.
Lamprang Kandai were arrested. In course of investigation, the accused person has revealed to the police that the consignment was handed over to them, that they were instructed to take the consignment from Kalyan on specific instruction by one Job Siangshai
Petitioner hearing.
from Ladrambai, hailing from Ladrambai. Accordingly, the said Job Siangshai was also arrested in connection with the case, which by then has been registered as
Lumsnong PS case number.
Lumsnong
PS case number 10.
PS case number 10
bracket 03 of 2023.
3 of 2023.
Under section 21B, 29.
Section 21B of the NDPS Act.
21B and /29.
Oblique 29.
NDPS.
In course of the proceedings, one of the co-accused, one or both.
After charge sheet was filed, then the accused, one of the accused was released.
Only one.
Yes.
In course of investigation, the IO has seized the said materials and also has examined relevant witnesses and has complied with all the due procedure, and accordingly a charge sheet was filed, wherein the IO has found that a prima facie case is well made out against all the three accused.
All the three accused.
All the three accused therein, and they are directed to stand trial before the competent court of jurisdiction. There is a rider, however, as far as the charge sheet is concerned, wherein the IO has made a prayer that since the FSL expert analysis opinion with regard to the seized material not having been received, therefore it is prayed that as and when the said FSL report is received, a supplementary charge sheet will be submitted before the court. In the meantime, one of the co-accused, that is who's
Lamprang
Kandai, was released on bail
on 18/5.
On
18/5
2023 by the London Special Court,
Special Judge
NDPS
Clarion.
The petitioner herein has approached this court with this application under 439 CRPC seeking bail, firstly on the ground of parity.
Sorry to interrupt, but as far as parity is concerned, my lord, my lord, the question here is whether the same can be applied to the petitioner's case, my lord, because the person who has been released, my lord, his statement is that he was only the car belongs to him, my lord, whereas in the report says that the main peddler was Raju Dakhani, and he has accused that he is the main person who has ordered money. So, my lord, in this
That is okay. He that is his. Sorry, the court can ignore that. But the thing, Mr. Sarji, you see, however or empathy or sympathy lies, that the authority by Supreme Court is very clear. So he has to be let off. If it is up to me, it would not be so. And also, on the ground of parity, in as much as since one of the co-accused have been released on bail, the same benefit should be extended to the petitioner herein. However, the main thrust of the petitioner's argument is that the charge sheet filed by the IO is incomplete, since the prayer was for filing of the supplementary charge sheet after receipt of the FSL report, a relevant FSL report. This, according to the learned counsel for the petitioner, amounts to an incomplete charge sheet, which could also be termed as no charge sheet at all. And therefore, on this premise, the petitioner accused, having been in custody for more than 100 days or so, is therefore entitled to be granted default bail under section 167(2) CRPC. To further buttress his contention, the learned counsel has referred to the case of Divyas Bardeva versus Narcotic Control Bureau, wherein the Honorable Supreme Court in SLP, special leave to appeal under bracket criminal CRL number 11628/2022 by order dated 1/5/2023. This is the final order.
No, Your Lordship, this is not the final order.
Matter is pending.
Matter, it will take some time. That in the meantime, the Honorable Supreme
Has
Court
passed an interim order relating to the parties therein, inasmuch as the petitioners in that case who were in custody in connection with a case under the NDPS Act and who had been in custody for some time have been directed to be released on bail. Where is the Where is it stated with regard to the charge sheet or FSL report?
Yes, Your Lordship, in first page, the preliminary questions are to be urged in the instant petition with regard to petitioner having acquired a right to sit, since the charge sheet file is without FSL report. First page.
The main consideration before the Honorable Supreme Court is on the aspect of a charge sheet file sans the FSL report, and the matter being under consideration before a larger bench.
Constitution bench.
Yes,
before a constitutional bench. Where is it written?
Your Lordship, it is
Doesn't
in a
say-
batch of petition. The issue is pending consideration in batch of petition. It is just, which would take some time.
So in this case only, not before a larger bench.
And I don't think it is not specified here.
Not say.
It is pending before the Honorable Supreme Court for consideration.
Gumrum to kau? And before the issue could be settled, considering the fact that the petitioner are in custody for quite some time, therefore the grant of bail. The learned counsel for the petitioner has also submitted that following the rationale of the said order dated 1/5/2023 passed by the Honorable Supreme Court, the Honorable High Court of Madhya Pradesh in miscriminal case number 20197 of 2023 in the case of I can take more by order dated 11 May 2023 has allowed the applicant therein to be released on bail. On condition imposed therein. Another next order passed by the Honorable Delhi High Court in the case of Ansar Ahmed versus State under bracket NCT of Delhi. No, this is not based on that.
Not based on that, just intermediate quantity based on that.
Was cited by the learned counsel, wherein the Honorable High Court, in an application for grant of bail, in an application seeking grant of bail under similar facts and circumstances as the present case, inasmuch as in the case under consideration before the Honorable Delhi High Court, the charge sheet has been filed and the petitioner therein was arrested on the basis of disclosure statement of co-accused persons, and also the recovery of the alleged contraband item or psychotropic substance was only of an intermediate quantity. Considering the fact that the trial may take a long time to conclude, the Honorable Delhi High Court has accordingly granted relief to the petitioner by directing him to be released on bail. Similarly, in the case of Deepak Gupta and others versus UT of J&K and another, the High Court of Jammu and Kashmir and Ladakh, in a bail application, has allowed the same, inter alia, opining that the rigors of Section 37 of the NDPS Act will not apply to a case where intermediate quantity of narcotic was recovered from the applicant therein. Next. This court, on consideration of the authorities cited, particularly the case of Divya Bardeva Supra, which more or less is similar to the which issue is more or less similar to the issues involved in the case of the petitioner herein. The prayer made for grant of bail has to be allowed. Accordingly, the petition is allowed on condition that the petitioner shall not abscond or tamper with the evidence and witnesses, that he shall cooperate with the IO as and when required, that he shall not leave the jurisdiction of Meghalaya without prior permission of the IO or the court concerned, and that he shall furnish a personal bond of 2 lakhs with one surety of like amount to the satisfaction of the IO. Failure to adhere to any of the conditions stated above will render the bail granted to be automatically cancelled on application of prayer made in that regard. Petition disposed of. No cause.
To the satisfaction of IO, Your Lordship.
Because it's under investigation, isn't it?
No, Your Lordship, charge sheet has already.
Oh, sorry.
The FSL is still
No, that is okay, but charge sheet has been filed.
FSL.
But I've said IO or court concern.
Additional charge sheet.
Yeah, because additional charge sheet.
Yes, but
Question of additional charge sheet is there.
Court, it's better to the satisfaction of honorable
both
court.
The options are there, my lord. The additional, because FSL report is still awaited, additional charge sheet is there to be filed.
Like I said, if it's up to me, you will not get bail. Drugs, menace is too much. Too much. Lord, youth are being destroyed.
Exactly.
At least police are doing something about it.
Yes.
That's some, this is some, what should I say, something to cheer about. Otherwise, I think it's a collective responsibility of all concerned, as far as this menace is concerned. Thank you. What do we do?
This item number 1 for hearing.
Yes.
So, Your Lordship, in this matter, I have prepared this short submission.
Yes, Miss. Tell me.
May I submit Your Lordship this one? Copy to
But I have not. Have you made your submission? Have you respond to the submission of the council?
It was already says are good, so I have prepared one little submission of mine. So I am giving the copy.
But I still have to hear you.
So you will see, after going through it, it will be required for personal hearing. Actually, I was having some little bit
That is not the
today.
order. That is not the order. The order is first the oral submission, thereafter the written argument.
So Your Lordship, actually, I was having little bit problem in the second half, so that's why I have taken in other adjournment also. I was thinking this it will be matter of while. It was in the first item. So if you kindly, Your Lordship, will allow me to.
You have to seek her permission. She is coming from. She's coming from.
Whatever I am in submission details, this I given this matter.
Mr. I will argue my part today, and I do not know after.
You have not completed your argument.
Yes, Lordship.
So he has not completed.
Last week they completed. That's why I was thinking.
Partly heard, Lordship. I could not complete the case.
Yes. So what we can do?
I was having a little bit.
No. You don't have a your colleague with you. Or?
At the moment, no, Your Lordship, that's why.
Yes, Miss. You going back to Guwahati today?
Yes, I want to complete the
matter. Is there any court tomorrow in Guwahati?
Guwahati, I have some cases, Lordship, up to next.
If it is possible, you can always address the court through virtual mode.
Today, Lordship.
Tomorrow. So maybe we'll the hearing.
Tomorrow, Lordship.
First item will.
Yes, Lordship. Otherwise,
then at least we'll complete your hearing, and then he will respond.
They do it after tomorrow, Your Lordship.
Tomorrow? Why day after?
Tomorrow, actually, I have.
No, day after I am not in a position.
At least to that extent, we have accommodated. She has accommodated you rather.
Last occasion, 4 occasions.
Last occasion, you just disappeared without even appearing in court.
Your Lordship, this I thought, and I was having the
and I went has told you.
And I tell this I'm coming, and by this time court is over.
I don't know why you're so afraid of her.
Actually, I was not in my room, so I went to the session today.
Tomorrow is better.
Somebody,
in fact, tomorrow actually some enforcement matters will be Your Lordship, so I should be that's why.
I have also some matters
even tomorrow also, because there will be division benches going. So perhaps this matter may be taken up only after 12 or so. Not exactly at 10:30. So you adjust your timing accordingly.
After 12?
Yes. It would be after 12.
Because earlier,
otherwise we can take in
all friends, they waited. He left.
Your Lordship, otherwise you can take tomorrow at 2, Your Lordship. Generally it is coming in the second.
Okay. So we'll take it up at 2 then. At 2? You can adjust your
yes,
case accordingly?
Yes, Lordship. Oblige.
This matter tomorrow.
First item, Lordship. Oh, yes, at 2 p.m.
So at 2 p.m.
So I'm giving you advice yesterday.
Fine. Thank you.
My Lord, Your Lordship's indulgence. One matter is left, item number 15, my Lord.
Item number?
15, last item.
15, my Lord, a very short question of law is involved. But I think today, my Lord, whether the court will be able to take up the matter or not. Only anxiety here is, my lord, because the matter is fixed at the trial court on the 26th. Now I have also prayed for stay, but I have not pressed for it because I want to finish the matter as soon as possible. Now, my lord, if I can only pray that the matter can
What
be
is the matter?
Well, here the short question of law involved is whether the registrar of NEHU is the competent authority to grant sanction for prosecution of a government servant.
But sanction is usually granted by government.
My lord, the Act says, my lord,
appointing authority.
By the appointing authority. Here, my lord, in my humble submission, the appointing authority is admitted position is the Executive Council, my lord. The Executive Council is a body, my lord. Now, Executive Council as a body cannot communicate with or correspondent. It has to correspond through somebody, my lord.
But not the registrar, my lord. That is my case.
And registrar is the authority, my lord, to...
Registrar or VC?
Registrar. It should be the VC, my lord. Registrar generally for other communications, obviously registrar. But when it comes to prosecution sanction, because some application of mine has to be there. Now, my lord, the registrar on his own cannot apply his mine and for sanction because...
The application of mine has to be on the part of Executive Council, my lord. Not on the part of registrar, is simply communicating.
So that is an issue of law then.
That is a very interesting issue, in fact, my lord.
Interesting.
So, my lord, if today I can pray, because, my lord, it's already late also. The matter is coming up on Monday. My lord, we don't want to stall the matter in any case. So, if my prayer for stay only when you grant it till the next date, within, I think, a couple of weeks we can finish the matter. Because even it's a very short question. A couple of case laws will be filed, and I'm sure my lord senior also. Only for one day.
To concede to stay.
When is the matter coming?
Monday, my lord.
Monday. Today we are
on Tuesday.
Tuesday.
I will make given undertaking. I will not pray for any further adjournment or further stay if we cannot finish the matter within a month.
We can have it tomorrow also. I have no problem. My lord, or Friday also. My lord.
Tomorrow again the fixed matter is also coming.
It's a very small matter. My lord. In my humble submission, there is no merit in this case.
Friday.
If a lordship just turn to that page, sanction order, my lord, there itself it is said the decision of the Executive Council. Simply
communicated by the registrar. Well, that is the entire thing.
Either tomorrow or Friday then.
Friday.
Tomorrow. I'm okay, well, tomorrow also.
Well, Friday I think perhaps because tomorrow again this matter is also there then.
What to do?
But stay, I have some objection.
No, Friday is okay because matter is coming on Monday.
Friday.
Friday then.
On pre-meet by the parties, this is matter on Friday.
Right.
Much obliged.
We have another matter. What is there? Yes, item 5.
If my lord want to take after break or...
Up to you. Up to the parties. If we are...
Parties is here.
All the parties are here.
Or your lordship feels something that may be taken up tomorrow.
push my lord.
No. That is not. I am not pushing. In case your
the court is here.
You know, okay.
Court is here.
After break. After break, we'll finish it.
Now it's 2:33.
2:30 already.
So 3:15.
3:15.
It can be taken up tomorrow also. One fixed matter is there, and then tomorrow we can do it, my lord. I have no difficulty.
What is the urgency here, Mr. Hajarika?
No, it is Nokma matter long pending, my lord.
No, you see, there are matters here which are 2013, 2014.
No, because my learned friend all the time they are objecting for that.
Who is
They are
objecting?
making
Last time I have seen through the VC, my lord. My learned senior was objecting because I was not well, and he was harping over my colleague.
No, not harping because he is legally he is not.
I was sanctioned.
He is not.
I was on sanction leave.
No,
I was on sanction leave, my lord.
No, that time I didn't object. No.
You can check your YouTube.
No,
Probably
no.
you are getting old.
I told that the next time because he was on leave.
Fine. We'll take it after 1 week then.
Yes.
Not 1 week. Tomorrow, my lord. Tomorrow we'll finish. Not today. Not today. Tomorrow. Tomorrow, my lord. Tomorrow after the matter, fixed matter, we'll do it.
Fine. On pre-meet by the parties, let's this matter tomorrow.
Itu NDPS
your name? Hey, average.